can be very, very technical. So what we're going to do is really go through the actual regulation itself. So this, obviously, as we know, during these pandemic times and so on, we are undergoing, many companies out there undergoing a difficult business situation, and many are closing down their branches, or maybe even there's been a downslide in business. Hence, there are many retrenchment going on. So in this respect, whenever a retrenchment goes on, the companies may end up retrenching its employees, and as an end result, they find themselves having to pay termination and layoff benefits. So in today's session, we're going to go through the actual regulation which regulates termination and layoff benefits, how it, to which category of employees it applies to, number one, under what circumstances we actually do pay termination benefits, number two, and how do we compute these benefits. So moving on, the first thing that we have to, that strikes our mind is, this is a regulation. And as you know, all forms of regulations as per the law is, it actually comes under a principal act. So which the employment termination and layoff benefit regulations, the first thing we have to ask ourselves is, it comes under which act? So basically it does come under the Employment Act. That's what we have to bear in mind. So as we can see here, under 60J, Section 60J of the Employment Act, it is stated here that the minister may, by regulations made under this act, provide for the entitlement of termination benefits and layoff benefits and retirement benefits and so on. Hence, this is how the regulations are made. Employment and termination and layoff benefits regulation, it is actually made, it is actually provided for under the Employment Act 1955. So the second thing we have to bear in mind is that these regulations only apply to those who are employees under the purview of the Employment Act 1955. For those employees who do not belong to the purview of Employment Act 1955, these benefits regulations do not apply. So then again, we have to go back, just briefly going back to the definition of employee under the Employment Act, as we all are aware of being in HR. Number one is those who are earning 2,000 and below and so on. Manual laborers, those who are involved in manual labor, at least 50% of their working time, and also supervisors of manual laborers and so on. We can find this under the definition of employees, can be found under the schedule of the Employment Act. So having said that, so we are aware that the regulations is derived from our Employment Act 1955. Secondly, it only applies to employees under the Act. So what does this employment termination benefits regulations request us to do? Under Regulation 3, it is stated specifically that employers are liable to pay termination . I hope you all can hear me. To employees who have been employed under a continuous contract of service for a period of at least 12 months when the contract of service is terminated or laid off. So we have to look into several aspects in this. Number one is we have to look into the aspect of termination or layoff benefits. What are they? Number two, what is meant by continuous contract of service? Number three, 12 months. How does this 12 months adapt itself into the regulations? Number four, what is the meaning of termination or layoff? So these are the aspects we have to look at when we look into the employment termination benefits regulations. So we should start under Regulation 3. What we'll do first is we will try to define the meaning of termination or layoff. Number two, the amount of termination or layoff benefits payable. Number three, continuous contract of service of at least 12 months. So moving on. Okay, when we look at a termination or layoff under Regulation 3, so this specific provision provides, if you look at the regulation, what it actually does is, it actually lays down the conditions whereby where termination benefits are not payable to employee rather than when the employer is supposed to pay. So it's reciprocal, it's the other way around. So it is stated employee shall not be entitled to termination benefit payment if, number one, attaining retirement. And as we all know, we have the Minimum Retirement Age Act, which stipulates that employees are bound to retire at the age of 60, minimum age at 60. Number two, employees shall not be entitled to termination benefits if they are dismissed due to misconduct, obviously after due inquiry. If you dismiss an employee without due inquiry process, then if the situation goes to Labour Department, then the termination benefits may become payable as ordered by the Labour Department. Before moving on further, I'd just like to remind you that since we're talking about the regulations, any issue in terms of the termination benefits, they all come under the purview of the Labour Department and not the Industrial Relations Court or Industrial Relations Act. So since it comes under the Employment Act, the issue in relation to termination benefit always comes within the purview of the Labour Department. So not IR Act, it's under the Labour. So as we can see here, under dismissal due to misconduct, if you don't perform an inquiry process prior to dismissing the employee, there's a huge chance, if it's brought to the Labour Department, they will rule against their company and order the company to pay termination benefits in favor of the employee. So, which is what is meant here. So, as I mentioned earlier, what Regulations 3 actually lays down is all the conditions in which case the employee shall not be entitled to termination benefits. Conditions which they are not entitled to, rather than what are the conditions which employers have to pay termination benefits. It's the other way around. So thirdly, when you look at it, another category, another application whereby the employee will not be entitled to termination benefits is that when they voluntarily resign, when they leave the company voluntarily, then obviously you do not have to pay termination benefits. Of course, there's a caveat there, other than under Section 13.2. When we look at the Employment Act Section 13.2, what we see is a clause dealing with termination due to willful breach. So it simply means that if the employee, if either party, the employee actually leaves, claiming that the employer has willfully breached his employment contract, then obviously the employer is bound to pay the termination benefits. Let's take into example, for example, like the CMCO regulations, for example, has stipulated work from home between 9 o'clock to 2 o'clock and so on, 3 times a week. At maximum, you can appear at work for certain category of employees. Let's say, for example, if the employer orders the employee to breach the CMCO rules, regulations on work from home and request him to come on the day where he's not supposed to come to the office, well, the employee has a right to claim willful breach. And in case the claim becomes successful at the Labour Department, then the employee is bound to pay termination benefits. So that is just one example of willful breach. Secondly, it's also mentioned, shall not be entitled to termination benefits other than the reasons stipulated under Section 14.3. Section 14 sub 3 is in relation to an employee who terminates his contract on account of threat or imminent danger to himself or dependents. So we usually don't refer to these clauses very much because most of the time we find ourselves dealing with cases that go before industrial court rather than the Labour Department. But there are some cases that go to the Labour Department. So in this case, occasionally when an employee terminates his contract, assuming again a similar situation as I mentioned earlier, as example, if we request the employee to appear at work in the office, but the employer is not supposed to come to the office, then obviously the employer is bound to pay termination benefits. So during CMCO, for example, and employee terminates a contract because he feels that there is some sense of danger of him coming to work because of the threat of the pandemic or the virus, then he can terminate his contract under Section 14(3). And if he is able to do so, he can lay a successful claim at the Labour Department to claim for termination benefits. So bearing that in mind, so these are some of the conditions there where the employee shall not be entitled to termination benefits payment. Other than these conditions, the employee shall be entitled to termination benefits, which we will look into the conditions in a future slide. Moving on, in another situation whereby the employee shall, we are still on Regulation 3, by the way. It is a very lengthy section, very lengthy regulation. The employee shall not be entitled to any termination benefit if his contract of service is renewed or re-engaged on terms and conditions which are not less favorable. So assuming that you have a fixed term contract, 12 months fixed term contract, and the employee renews the fixed term contract without any, immediately, which takes effect immediately right upon the expiry of the fixed term contract. So obviously the employee is not entitled to any termination benefits because it is renewed successfully. It is renewed immediately under terms which are not less favorable. So under a circumstance like this, then yes, the employee shall not be entitled to any termination benefits. Moving on, if you have any questions, you can type your questions. Our organizer will relay it to me. In the meantime, we shall move on. The next few issues, the next few categories of conditions whereby the employee shall not be entitled to termination benefits is the fact when more than 7 days, this is also found under Regulation 4, sorry, where more than 7 days before the termination, an offer to renew the contract of service or to re-engage on no less favorable terms is made, and he unreasonably refuses the offer. So if more than 7 days before any kind of termination, the employer offers to renew the contract and the employee refuses unreasonably, then the employee shall not be entitled to termination benefits. Then again, this is a situation whereby the Labour Department, it's up to them to decide whether or not the employee had unreasonably refused the offer or not. So what is unreasonable, obviously, sometimes depends on the decision maker rather than up to the company or the employee. Moving on, G, where the employee leaves before the expiry notice without the employee's consent or without paying indemnity. We can liken this situation to a situation of AWOL, for example, when the employee suddenly disappears in this kind without paying indemnity. So in this kind of circumstance, you don't have to pay the employee any kind of termination benefit because the employee is left before expiry of notice or without the employee's consent, and he did so without paying any indemnity in lieu of notice. So obviously, this kind of situation, you don't have to pay termination benefits. So as I mentioned earlier, we're looking at the regulations 3 and rather to 4, sub 3 and 4.4 of the regulations actually talk about situations or conditions whereby the employee is not entitled, rather than situations or conditions whereby the employee should be entitled to termination benefits. We're looking at it the other way around. So moving on, we have other areas whereby now we're talking about change of ownership in business. So in a situation where there is a change of ownership of business, where within 7 days of the change, an offer to continue employment at terms which are not less favorable is made, and the employee unreasonably refuses the offer again. So whenever we have a change of ownership, okay, let's take a look at what is legally meant by change of ownership. We look here in this slide for the transaction to amount change of ownership of a business there must be a transfer of a business as a going concern. So transfer of operations, trade, business, and not transfer merely of physical assets or shares. So what we have to do firstly is define what exactly is ownership, change of ownership. So what is meant here, as we can see here, based on the cases of Dalal Industrial Properties versus LC, as we can see here. And the second case, which is cited as Abdul Aziz bin Atan versus Rango Mele Estate Sdn Bhd, whereby an actual change of ownership of a business, there must be a transfer of a business as a going concern, which actually means transfer of operations, trade, business, and not a transfer merely of physical assets or shares. So you find many situations whereby in a business concern, where there's merely a transfer of shares, for example, from one partner to another, one company to another, or merely sometimes they buy and sell assets. So that alone does not amount to change of ownership under the regulations. So in this kind of situations, whereby it's not a valid change of ownership, termination benefits does not become payable. We shall take a look at it again. Okay. An employee shall not be entitled to any termination benefits if there's a change of ownership of the business. So we have to look at this word. So within 7 days, let's say what does it mean by change of ownership, as we mentioned again? So there must be a sale and purchase agreement at least. So let's say within 7 days of the change of the sale and purchase agreement of the change of ownership on offer to continue employee, and whereby the employer, the future seller, for example, sorry, the future buyer, in a change of ownership, there's a buyer and a seller. When the future seller actually offers the employee terms and conditions to continue employment at terms and conditions which is not less favorable, and the employee unreasonably refuses the offer, then termination benefits shall not be payable. Which actually means, on retrospect, what it actually means is the fact that if the future seller, employer, gives terms and condition of service which is favorable to the present terms and conditions of service, and the employee accepts, then termination benefits may not be payable as well. So, okay, do you all have any questions? Our organizer can relate to me. So far, do we have any questions? Okay.
Yes. There is one question. Is this applied change of ownership within the same group of companies as well, provided it fulfill the business transfer definition?
Okay, that's a good question. Does it apply? Does it apply within the group of companies and so on? Okay, so as I mentioned earlier, so this is actually based on case law. So it's very particularized to the facts and circumstances of the cases that we've had. So what the courts actually look at is the circumstances as a whole. Number one, the change of ownership. Who are the owners? Is it the same directors within the group of companies? It's actually a very, it can be it's a question of law. Secondly, they look at situation whereby the change of ownership, whether there's a common director, common secretaries, common board of directors and things like that. Number two, they look at whether in the change of ownership, whether there's a change of, does the trade, business, clients, everything, lock, stock, barrel, is it transferred upon the change? Is there a change of name? So there are many factors to look at. So this is actually a question of law. Unfortunately, we don't have that many. We've done some research on this area, and we don't find that many cases to actually suggest to us or actually help us how to actually define a change of ownership. But what we do have is the fact that these two cases have told us, number one, change of ownership. If there's a transfer of operations, for example, there must be a transfer of operations. Number two, the trade, the actual trade, there must be a transfer of trade, trade, the ability to trade transfer from A to B. the ability to operate a business transfer from A to B, and not just merely a physical asset transfer or shares. So which means that if I buy a certain part of the company, the furniture, company A buys the furniture or the office assets of company B, is that a change of ownership? Obviously not. So secondly, the company A buys shares from company B, for example. Is that a change of ownership? No, that happens in our Bursa Saham all the time. Huh? Companies are trading shares, their own shares all the time. People across the globe are buying and selling shares. So that does not amount to change of ownership. So other than that, we have these two cases to explain to us as far as that. So other than that, we really don't have that many case laws because it's actually a question of fact and law. So when we talk about group of companies, within a group of companies, there can be a change of ownership if there's a change of directorship and so on. It can be. It can be. So they have to look into many, many factors. Sometimes within a group of companies, there's a change of ownership and so on. And there's a change of directorship, number one, this company breaks away from the group of companies, resulting in the company actually breaking up from the group of companies, then yes, then that could be an actual change of ownership, yeah. But strictly speaking, if it's within the group of companies per se itself, most of the time it's not considered as change of ownership because the directors remain the same. They still have a common director. So okay, thank you very much for the question. Any other question from Umi? Okay,
no question.
Sorry?
No question.
Okay, no issue. We shall move on. Okay, now as we know, the entire regulations is coined or is termed as Employment Termination Benefits Regulation. Employment termination and layoff benefits are layoff. We always forget to emphasize, we always look at termination benefits, but we forget to emphasize on layoff. We've had many queries on the subject matter of layoff from many of our clients. So let's take a look at layoff. Okay, layoff is another part of Employment Termination Benefits Regulations, comes under Regulation 5 of the regulations, whereby it states here, number one, where an employee is employed on such terms that his salary depends on him being provided with work. Number two, he shall be deemed to be laid off if he is not provided for work for at least 12 working days within 4 weeks. And he is not paid for this period of not working. Let's take a look at our next slide before we make any conclusion. So does Regulation 5 give the right to lay off employees? Yes, it does. But it only applies to employees whose remuneration depends on being provided work, i.e., if there's no work, there's no pay. In other words, this is referring to daily rated or piece rated employees and not monthly rated employees. So for those companies or clients out there who actually employ employees on a daily rate or piece rate simply means under Employment Act, it simply means that when there's work to do, I pay you to do the work. If there's no work to do, I do not pay you. So they only apply for those categories or under those circumstances, the situation, the circumstance of laid off under the regulations. So for those who are being paid piecemeal, for example, or daily rated, if they are not provided work for at least 12 working days within 4 weeks, then yes, these kinds of employees will be able to claim termination benefits. The usual calculation we will look at later as per what is mentioned under the regulations for termination benefits, same mode of calculation. So if there's any one of you out there, any one of our clients, ILO members or even non-members who actually employ workers who are under piece rate, is there anyone out there who employs on piece rate or daily rate? Then yes, if you're not able to give the employee work for 12 working days within 4 weeks, then you are bound to pay him termination benefits. And obviously the employee is terminated. If 12 days you're not able to give the employee work, he is terminated and is able to claim the benefits. You can rehire the employee later on, but you have to pay the benefits first. So if you have any questions on this issue, kindly, you can always chat with us for the moment. So I hope we made it clear. So right now we should be familiar with the conditions whereby employees shall not be entitled to termination benefits, retirement dismissal due to misconduct, voluntary basis, section 13, 14, etc. A renewed contract of service, and 7 days and things like that, where the employee refuses the offer, and also it's not entitled to termination benefits when the employee leaves, it just absconds from work without the employer's consent or without paying indemnity, then obviously you do not have to pay termination benefits. So, and also in terms of change of ownership, that's another important area we have to think about. Okay, and laid off. I hope we've covered this area well. Laid off is pretty easy. If any one of you actually employ staff or employees who are daily rated, yes, you are able to prescribe to termination benefits if you're not able to give the person work for at least 12 days, within 4 weeks. Other than that, for monthly rated employees, laying off does not apply, because we get a lot of queries from our clients, but they all are monthly rated schemes. They are monthly rated or salaried employees. So we're not able to apply layoff under the termination benefits regulations on these kinds of employees because they're simply monthly rated. So layoff is not meant for them. So I hope we made this clear. And okay, now we move on. We've had a case law.
Wait, Mr. Vishnu, there's one question from Tipan Manokaran asking that means this section does not apply to monthly rated workers?
Yes, you're right, Mr. Tipan. Thank you for your question. Yes, layoff does not apply to monthly rated workers unless you have workers working on daily rate or piece rate. Piece rate meaning that he works, you pay him. He does not work, you don't pay him. Only then it applies. If all your employees are monthly rated, you do not have to worry about Regulation 5 on layoff at all. Thank you. So I hope we've got that settled. Okay, now let's take a look at a High Court decision, in fact, of Viking Scheme Sdn Bhd, whereby the High Court actually said that, well, what the High Court did was actually affirm what we just mentioned earlier, whereby Regulation 5 did not apply to the company's employees in this case, simply because they were monthly rated and their remuneration did not depend upon work being provided by the company. So what we've said earlier has been affirmed by the High Court in Viking Scheme, so you don't have to worry, it is a correct piece of law. Okay, because we had quite a number of theories on this aspect about laying off, but it does not apply to monthly rated employees. Any further questions from Mr. Tipan? Thank you for your questions so far. Thank you very much. So, okay, now we move on. Okay, as I mentioned earlier, we've been through that regulations has actually talked about the conditions or situations whereby employees shall not be entitled to termination benefit. Reciprocal is the other way around. So what we're going to do is we're going to examine the issues or categories of areas whereby when the employer is bound to pay. So what the regulations actually mention is when you do not, you don't have to abide to pay termination benefits. So under this part, we looked at when we are actually bound to pay termination benefits under for those employees under Employment Act 1955. So number one, obviously this is a very, very common situation that is taking place these days, which is retrenchment. Unfortunately, it's been a trademark of the day, whereby a lot of companies due to downturn in business and so on have been due to resulting losses and downturn have been resorting to retrenchment as the last resort. Not forgetting that the government, obviously, end of the day, we have to remind ourselves that retrenchment per se is not entirely sometimes may not be the best option, because the government has actually initiated many programs, especially under our Prihatin program, Prihatin 2, for example, whereby under Prihatin 2, whereby employers are given some benefits for retaining employees. So we shall look into those aspects as well, just to kindly remind all of you. So other than that, when it comes to retrenchment, redundancy, business closure, and so on, this is a situation whereby we end up having to pay termination benefits only for those employees who fall under the Employment Act, like I mentioned. Under the Employment Act, as we're all aware, for you to qualify to be within the purview of the Employment Act, number one, you have to be earning 2,000 below, or a manual worker within the Act, within the meaning of the Act, or at least 50% of the time you're performing manual work. So as you can see, it is very subjective who actually qualifies to be a manual worker under the Employment Act. There have been cases that have gone up right up till the English House of Lords to decide who is actually a manual worker. So it's extremely subjective. Unfortunately, that's how our Employment Act works on some areas. So number three, obviously supervisors or manual workers and so on. So these are the categories for employees who are actually where the company is bound to pay termination benefits. Number two, per performance. Okay, per performance is an issue, because you see, end of the day, per performance is not a misconduct, and per performance, in actual fact, definitely does not come under the areas which we mentioned just now. It does not come under Regulation 3, whereby employees shall not be entitled to termination. It is outside Regulation 3. In other words, it is outside of retirement, dismissal, voluntary resignation, and so on. So when it comes to per performance, in actual fact, because it's outside of Regulation 3, in actual fact, when we terminate an employee who is under the Employment Act, not only we are bound to provide notice as per the employment contract, we are also supposed to pay termination benefits, in actual fact. So we have come across situations like this, decisions like this being made by the Labor Department. So as you know, this is not an area for industrial court. It's an area for Labor Department, Labor Court. It's a labor decision because it's pertaining to the Employment Act. So how many of you have not paid your per performer termination benefits, especially with under the Employment Act? I'm sure there's many of you. Okay, because it's not common. It's not commonly known that in actual fact, per performance, if you dismiss someone who's a per performer on the grounds of per performance, you actually, in actual fact, you have to pay termination benefits. Because, as I mentioned earlier, it's outside the scope of Regulation 3. Okay, so that is one aspect we have to look at. Number three, frustration of contract. This is another area where we end up paying termination benefits, but this area of law is highly disputable, because frustration of contract is when an employer and employee goes into an employment contract, but a supervening event happens to prevent either party from performing its obligations under the employment contract, if you know what I mean. So the definition of frustration of contract is that something happens in which case either party is not able to perform his duties under the contract. So there is no termination per se from either the employer or employee. So which is why we've come across cases from the Labor Department, instances from the Labor Department, we've been through this before, whereby they've actually ruled that if an employee is dismissed due to frustration of contract, or his employment contract is frustrated, the employer is actually obligated to pay termination benefits. Although this issue is highly disputable, because as I mentioned earlier, based on the actual definition of frustration of contract itself, there is no termination, because neither party actually terminates the employment contract. What actually happens in reality is a supervening event happens and breaks the contract. We can take one example, for example, MCO, for example. just as an example. But unfortunately, the MCO was regulated by the government. In actual fact, when the MCO happened, many parties, some parties, we were not able to work, and the employment contract was actually frustrated. If not for government intervention and regulations under the MCO order, it would have considered to be a supervening event to frustrate the contract. And if the employer had actually terminated the employee due to the MCO, if they had done that, then they would have had to pay termination benefits. So many other instances we can think of frustration of contract. Let's say, for example, employer and employee goes into a contract and the employee sustains injury. He's not able to work anymore. So in those kind of circumstances, the employment contract is frustrated because the employee is not able to perform his obligations under the contract anymore. What do we do? Obviously, end of the day, after giving him, the employee, his benefits, after giving all opportunities for him to try to get him back on track, but he's not able to, finally we come upon the decision to terminate him on the grounds of frustration of contract. So what actually happens is, the employer did not undertake to dismiss the employee. Rather, what happened was his injury disabled the employee from performing his functions under employment contract. Hence, the employer had no choice but to let the employee go. So there's no actual termination per se. That's an actual dispute when it comes to frustration contract, as I mentioned. So unfortunately, we don't have a case, a high court decision or from the higher courts to decide, to let us know for sure whether we have to pay termination benefits due to frustration of contract. But on the present premise, unfortunately, based on labor court decisions, looks like we have to pay. When we terminate someone who's under Employment Act on the basis of frustration contract, we have to pay termination benefits, even though, as I mentioned, it is disputable. So any questions on that issue, please feel free to chat up with our organizer.
Yes, we have one. We have three actually. All right. First question: can termination benefits be offered or paid to employees on merger with another company?
Okay, merger. Okay, now we're going back to merger. This is a change of ownership. Okay, fine. It's just that it depends. It is mentioned whenever you merge with another company, obviously. You're buying the other company. Whenever company A, for example, merges with company B, in other words, company A, either company is buying the other company. Company A buys the company B. So in this kind of situation, there is a buyer and a seller. So that is definitely termination benefits is payable, as I mentioned earlier, but unless, of course, within 7 days of the change of business, change of ownership, or change or 7 days of the actual merger and acquisition date, the seller, the new company, offers the employee from the buyer terms and conditions of service which are not favorable, less favorable, and the employee accepts, then termination benefits is not payable. It is only under that circumstance termination benefits becomes not payable. Other than that, it becomes payable. For example, A merges with B, but B offers the employee not so favorable terms and conditions of service. So do you pay termination benefits or not? Yes, you pay. But if A merges with B and B offers employees of A good, favorable terms and conditions of service, and employee A obviously accepts, do you pay termination benefits? No. So that's how it works. Any other questions? Sorry.
Yes, next one. How about if we transfer the employee and there is changes or add-on of JD? Is there any legal implication?
Okay, we're talking about quite a different issue here. Okay, no issue, no problem. We can actually talk about transfer. Transferring an employee to a different JD. So, okay, whenever you transfer an employee, the rule of the thumb is the law states that you have to transfer to a lateral position, to a lateral position, but it does not mention lateral job designation and so on, but lateral position, lateral seniority, meaning that the law requests or imposes the expectation of employer so that the employee who's transferred does not suffer from any kind of loss of seniority, loss of benefits, loss of salary, and so on. But the job designation depends. Let's say someone is an engineer. You transfer the engineer to a marketing department to do marketing for engineering equipment. Is that reasonable? Yeah, that sounds reasonable because it's still within his purview, it's still within his experience and within his abilities and qualifications and so on. But let's say he's an engineer. You transfer him to a medical department, let's just say, it's just an example. Does that make sense to you? It is a total change of JD from one job role to another, despite the fact that there's no loss of seniority, no loss of salary, and things like that, and so on. So this kind of situations, what do you do? This kind of situations, is that a lateral transfer? No, no. So again, we come across this kind of situations. We have to look into the fact and circumstance of each issue. And so we have to look into whether the transfer itself is genuine or mala fide, bona fide or mala fide. So as for your question, whether you can change the JD, yes, you can. The transfer, yes, in a transfer, obviously you have to change this JD because you'll be working in a different department and so on. But he has to agree, number one, because there's a change of JD. Number two, it has to be lateral. And number three, it must be within his scope of his abilities and his qualifications, so on. Number three. So if there's anything less than that, then it can be a disputed, it can be an issue with the transfer. Yeah, I hope I've answered your question. Any further questions?
Yes, next one. Do we need to mention termination benefits in staff's offer letter or just mention in company policy will do? When do we need to pay the termination benefit to the terminated or laid off staff? Any time restriction?
Okay, you do not have to mention because termination benefits, just like it's already the law. You do not have to mention. It's best, in fact, not to mention that a company is liable to pay you termination benefits as per. Why would you want to do that? So because it's really the law, the same way that many other aspects of the Industrial Relations Act, the Employment Act is all already under law. But it's better not to mention because sometimes if you mention the company is liable to pay you termination benefits under the term and regulation and all that, sometimes he may not be qualified for the benefits. But since you have mentioned it under his employment contract, then you become bound to pay it because simply you mentioned it under his employment contract. The employment contract is very, very sensitive. Please be careful what you mention there. The less, the better. Just the basic norms. The basic norms would do. If you mention that the company will pay you termination benefits, because sometimes he may earn more than 2,000K and he may not be qualified anymore. But if you mention his employment contract, then you have to pay him, law. If anything happens, he gets terminated, we end up paying him. Do you want that? Obviously not. So it is always best to keep your employment contract bare with the basic norms, your job designation, salary, job grade, etc., JD, your probation time, and your basic benefits, sick leave, hospitalization, public holidays. Keep it at that, and that's it. Because let the law take care of itself. We don't want to put too many things in there because you end up doing something that you don't have to do. Okay? So I hope that answers your question.
All right, next one. Does frustration of contract apply when an employee passes away? Where can we find Schedule 5 or 8 that you mentioned relating to change of ownership, etc.?
I come again, sorry?
Does frustration of contract apply when an employee passes away? Okay. And then where can they find Schedule 5 or 8 that you mentioned relating to change of ownership?
Okay, change of ownership is actually found under Regulation 8, under the Employment Termination Benefits Regulations. Please bear in mind, this is the Employment Termination Benefits Regulation, not the Employment Act. This is a regulations, totally different regulations. You cannot find this under the Employment Act. It is made under the power of Employment Act, but it's a totally different piece of legislation. Because we've had, I think I get what you're trying to say. You can't find it in the Employment Act because you can never find it there because it is a totally different piece of legislation. You can always Google it, no issues. You can find it. You can Google Employment Termination Benefit Regulation, and it's a separate act from the Employment Act. It's just that it's a regulation which derives its power from the Employment Act. So you can find change of ownership under Regulation 8. And as for your question, someone passes away during amounts to a frustration of contract. Yes, unfortunately, when an employer employs an employee, he expects him to live forever, right? He expects him to live for a long time and to serve each other faithfully throughout for a long-term career. But unfortunately, sometimes due to unforeseen circumstances and etc., the employee passes away. So yes, that becomes a frustrating event. And once the employee passes away, the employment contract becomes frustrated. Are you bound to pay termination benefits to the next of kin? That is highly questionable. Like I mentioned just now, frustration of contract is a disputed aspect, whether it's payable or not. So far, the Labor Department has actually requested employers, as far as we know, to pay. But as I mentioned just now, we find that to be disputable. Like for example, if someone passes away, on what basis do you pay employment termination benefits regulations to the next of kin? There is no such law. There is no such law. The only thing that applies is SOSCO benefits. So that's a good question actually. Like I mentioned earlier, even we disagree. Frustration on contract, when that happens, even though the Labor Department in many instances have said termination benefits are payable, we disagree on because it's disputable. So, okay, thank you very much for your question. We shall move on. When do we pay? Okay, now moving on to the next. When is unjustified dismissal? Okay, whenever we come across a dismissal, most of the time we find our disgruntled employee running away to the industrial court. But occasionally you find some of them going to the Labor Department for as a grievance process. So once the Labor Department goes through its processes and it finds that the dismissal was unjustified, it will order the employer to pay termination benefits. So these are the situations, one of the situations whereby we end up paying termination benefits. But what is justified and unjustified is determined by the Labor Department. Section 13(2), termination due to willful breach. As I mentioned earlier just now, we may end up paying termination benefits if the employee has just grounds to say that the employer has willfully breached his employment contract. Obviously, who will determine this? The Labor Department. For example, as I mentioned just now, when the employer forces, as an example, employer forces the employee to work in the office during CMCO or NCO and so on, and the employee refuses, he can actually invoke Section 13(2) of the Employment. This is from the Employment Act, by the way, 13(2) to say that the employer has willfully breached his employment contract, and he can go to the Labor Department and file a claim for unfair dismissal, and the Labor Department may rule the employer to pay up termination benefits and notice. So this is one of the circumstances where we end up paying termination benefits. As I mentioned earlier, Section 14(3), where the employee terminates himself because of on account of threat or imminent danger. He feels like the employment, his office is no longer a safe working environment. Maybe there's some predators, sexual harassment going on and so on, and he finds it no longer safe to work in that kind of environment. So in this kind of circumstances, he can invoke Section 14(3) to terminate employment contract and go to the Labor Department for reprieve, for termination benefits. Yes. So these are some of the conditions where employees may end up being paid termination benefits. So I hope we've understood to some level, to some extent. Okay, now we take a look briefly at the amount. As I mentioned earlier, what we have to do, what we have to oversee is the amount as well. We've all been through this before. The amount is based on the formula that's given under Regulation 6. So if an employee under Employment Act is 1 to 2 years of service, what is payable is 10 days wages for each year of service. For employees more than 2 years but less than 5 years, is 15 days wages for every year of service, and 5 years or more is 20 days wages for every year of service. As you can see, for those employees who have been serving more than 5 years, the termination benefits can be quite a big amount sometimes. Can be, if you look at it, because it's 20 days wages. If you calculate, if you compute at that basis, the wages can be very high. The termination benefits can be quite high. So the regulation 6 also mentioned that for an incomplete year, the calculation will be on a prorate basis. For example, the employee works 2 years and 6 months. Obviously, that becomes 2.5 years of service. So we prorate it. So it either falls under 1 to 2 years, or more than 2 years, less than 5, or 5 years of service. The next issue that we look at is how do we compute? So they look at true wages. Okay, so under the termination benefits regulations, the amount payable, it depends on the meaning of wages, which is the true meaning of wages under the regulations is true wages, whereby it is stated that under regulation 6, whereby wages shall have the meaning assigned in section 2 of the Employment Act, and a day's wage shall be calculated over a period of 12 complete months of service immediately preceding relevant termination date. So for example, you have an employee who is being terminated due to redundancy or retrenched due to redundancy on December 31st. So you go back 365 days or 12 months earlier to that, to assuming that he is being terminated on December 31st, 2020. So you go back to his wages that's been paid for 12 continuous months, which is 31st December 2019, right up to 31st December 2020, which is about 365 days. And 1 day's true wages would mean all those wages paid during that 1 year period, December 31st December 2019, right up to 31st December 2020, plus all the overtime paid, because the definition depends on section 2 of meaning of wages under section 2, which does not discount overtime at all, plus all its fixed allowances except traveling allowance. The reason why you don't have to include traveling allowance in your computation is because traveling allowance is actually under the meaning of section 2 of Employment Act, on the meaning of true wages under section 2, traveling allowance is not part of wages. That's why we can discount traveling allowance when we compute the meaning of true wages. So you divide that by 365 to get 1 day's wages, and then we just multiply that with either 10 days wages or 15 days wages or 20 days wages to derive at the amount of benefits payable. So I'm sure we've all done this before. It's just to refresh all of you. So we're coming towards the end of our session. Okay, the last part that we have to actually look at is we always have to bear in mind that under Regulation 3, subsection 2, it is stated as continuous contract of service, which means that it simply means that a continuous contract of service for a period of at least 12 months includes 2 or more periods which are more than 12 months in the aggregate, even though there's a break of less than 30 days. So whenever there's a break, when you have a fixed term contract, let's say 12 months, and then there is no break, the employer gives the same fixed term contract for the next 12 months. So this is counted as 2 years continuous contract of service, right? 12 months or 1 year plus 1 year becomes 2 years. But under Regulation 3 sub 2, it says, if you have a 30-day break in between this fixed term contract, 12 months and 12 months, then for the purposes of termination benefits, it is only a 1 year contract. You take the second half of the 12 months period. So only if you have a break, let's say you have a first fixed term contract, which is 12 months, and then you have a 30-day break in between, then we have following 12 months continuous fixed term contract. That's when the 30-day break will actually breaks the contract to mean that there's only termination benefits is only payable for 1 year and not 2 years. So the reason we brought this up is because we want to emphasize here, this 30-day break here is meant for computation for the purposes of termination benefits. By no means it has anything got to do with continuity of fixed term contract. This is actually for the purpose of termination benefits. It has nothing to do with on whether the fixed term contract is genuine or not. Please bear that in mind, because we've had a lot of issues or queries on what happens if I have a fixed term contract and then I give a break of, let's say, 30 days, and then I have another fixed term contract. Is that a continuous contract or not? Yes, it is still a continuous contract based on the rules of Hang Chiang. But if we want to talk about benefits payable, termination benefits under employment termination benefits regulations, then yes, it actually breaks the two continuous fixed term contract to one fixed term contract. So we only pay termination benefits of 1 year fixed term contract. But for the purposes of fixed term contract as a genuine concern or not, based on the rules of Hang Chiang, this 30 days does not apply. So it is actually, it's not a correct practice to apply 30 days break, etc. into a fixed term contract, just for the purpose of saying that, look, I have a genuine fixed term contract. It does not work that way. Okay, what if you want to break a fixed term contract, you have to give, let's say we have a 12 months fixed term contract, you want to give a genuine fixed term contract, give a totally different contract, change the job designation. Based on the Hang Chiang rules as we know of, you have to give a totally different job description, then it becomes a genuine fixed term contract. Otherwise, it becomes a continuous fixed term contract or a fixed term contract which is disguised as a permanent contract. So to employ this 30-day break to mean that it is a genuine fixed term contract, etc., does not work. It only applies to, as I mentioned earlier, just to reiterate, it only applies to the computation of termination benefits under the regulations. Okay, I hope we got that straightened out because we get a lot of queries on this issue. So will there be any further questions? We still have some time.
Yeah, there is one question. Is the unfair dismissal under Section 20 of IRA is also an unjustified dismissal?
Okay, yes, okay. Okay, see, the situation is we have two systems, even though it's not admitted, we have a system whereby if the employee gets terminated, he has a choice to go to either industrial court through making an application for unfair dismissal under Section 23 of the Industrial Relations Act, or where he can claim for back wages and compensation in lieu, or he could go to labor court. And labor court is a more simplified court where he can only claim for notice and termination benefits if he qualifies. So yes, unfair dismissal can be presided by two courts, but not both together at the same time, but it's either one. Either one. The law actually says that if you have a case going on for so-called unfair dismissal at a labor court, and at the same time you make an application at the industrial relations court, in the industrial court, what happens is the labor court has to stop its proceedings first, and then the industrial relations will continue with its processes. Once that is done, once that is concluded, only then the labor department can restart its proceedings. So that's all the law says. But at the end of the day, which means that an employee who gets dismissed can make a claim in both courts. For one, for unfair dismissal, for the issue is what kind of compensation he wants, whether he wants back wages and compensation for industrial court, or he just wants termination benefits and notice from the labor court. Okay? Any further questions? No issues? We still have time.
Okay, one more. When do the company need to pay the termination benefit in the event of retrenchment exercise? Any time limit as per the Act, or what would be the best practice?
Okay, yes. Okay, good question. Actually, in actual fact, what we have to do is when we pay termination benefits, we have 7 days to pay the termination benefits. Okay, but it's not so much of a serious issue as long as you pay, but it's 7 days. The regulation states it's 7 days. Okay, it comes under regulations. Any other questions, Umi?
Is there any prescribed law for ex-employees who are going to be rehired after receiving the termination benefits from the company?
Okay, an employee you've dismissed and they've received termination benefits, or employee you've retrenched and you want to rehire them back after you pay that payment, why not? The banks do that all the time because the movement in the banks, is very fast. It goes, the flow in the banks is very, very fast. departments gets closed down, departments get closed and reopen very fast because they move in tandem with the economy. So in the banks, it's happened before. It usually happens whereby they close down the departments, they pay termination benefits. And after some time, they decide to reopen because business flourishes for the department, and they rehire the same employees. So there's no law to say whether or not you can hire. So it's more of an internal policy. It's an internal matter, internal policy. And most of the time, yes, you can. Why not? You can give a chance for your employees you have terminated or retrenched, unless, of course, they've got a negative record. Then you may not want to rehire them back. But if they've left because they've been retrenched, or maybe no fault of their own, why not? There's no reason why you can't rehire them back. Because there's no law to say no.
No more question.
Okay, thank you very much, ladies and gentlemen, for joining us today. Just to let you know, please do not forget to fill up your the evaluation form at the end of this program. And also, I'd like to remind you that we have a few more upcoming webinar sessions handled by Ms. Selvakumar from Screen, I suppose, and another speaker. So thank you very much for joining us again. I hope you've enjoyed. I really enjoyed the session with you, all of you. Please continue. If you have any further queries, please email me. And those who wish to know more about IR Law services, please email us or click on our website. You will get a prize for clicking our website. I was just joking about a prize, but please click our website to gain more information. Okay, thank you very much, and we'll see you again.